Is the filter deactivation fee even constitutional? How can you legally justify that fee? Well, the Supreme Court has found over and over again that the state has a compelling interest to uphold community standards of decency. Paris Theater is one case by the Supreme Court that's pretty famous that holds that. And the fee is rationally related to a narrowly tailored, compelling state interest. And so it's going to be upheld as being constitutional. And there's basically three existing statutes that we relied on in coming up with this part of the bill. The first is a statute that Utah has. Another statute's a Texas statute and Pennsylvania statute as well. The Utah statute is a filter statute, and it does say this. It says that if you live in Utah and you have an internet service provider and you want to have filters installed, you can contact your ISP, your AT&T, Time Warner, AOL, and demand that they install filters, and the ISP then must install filters, but they can charge a filter installation fee. And so we filed a federal lawsuit to challenge that, to say, no, you guys got that backwards. And what should really be the case is that going forward, the internet service providers should sell their products and services with filters already activated and installed. And the consumers who want to have access to prostitution hubs, child pornography, revenge pornography, and obscenity, they should be the ones that have the burden to reach out to the ISP and the onus to then ask them to deactivate the filter. They'd also need to provide proof of ID that they are not a minor. And instead of there being a filter installation fee, there should be a filter deactivation fee that should go to the state to help offset the secondary harmful effect that obscenity, prostitution hubs, child pornography, and revenge pornography generate. So Texas also has a law that we relied on. Texas has a $5 strip club fee right now. It's a statute that permits that. So when a person goes to a strip club in Texas, they pay the admission fee plus an extra $5 to get in. That $5 then goes to a grant program that helps finance countless family groups within the state that are fighting domestic violence, prostitution, child neglect, human trafficking, and so forth. That statute in Texas has been challenged in state court, Texas state court. It went to the Texas Supreme Court in a case called Combs. And in relying on federal law, this Texas Supreme Court found that the $5 strip club fee was constitutional. On the exact same legal basis, the $20 filter deactivation fee is also constitutional. So that pretty much puts that concern to bed. Pennsylvania has a really good statute that creates a grants program that we relied on that finances all these family groups within Pennsylvania that are fighting human trafficking, divorce, child exploitation, domestic violence. The grants program is not going to just fund itself. This $20 filter deactivation fee goes to help finance that. It goes to help finance the Human Trafficking Task Force and Victims Compensation Fund. And so it's rationally related to a narrowly tailored, compelling state interest and is constitutionally valid.